All right. Well, hopefully everyone can hear me. I want to thank everyone for being here today virtually for our meeting of Judiciary Non Civil. I'm Chairman Chuck F. Stration. Appreciate all of our committee members who are here today. We'll be considering 3 bills in this virtual meeting today. This is a hearing only, so no votes today. And I appreciate the Senate sponsors who are joining us also virtually. What I'll ask members of Judiciary Non Civil to do is to utilize the raise hand feature. So if you click on I believe it's the participant link at the bottom and then raise hand, that's how you can, if you have a question for any of the witnesses that we'll be hearing from today, that you can make me aware of it so that I can recognize you. And this is, of course, our first virtual meeting of the committee, so we will figure this out as we go, and I appreciate everyone's patience as we work through this. So, all right, very good. The first bill that we'll call, we have 3 bills on the agenda today. The first bill we'll call is Senate Bill 394, and I saw that Senator Albers is on the call. And so at this time, I would ask House Media Services to unmute Senator Albers and allow him to proceed.
Thank you, Mr. Chairman. Can you hear me okay?
I can hear you, yes. Thank you.
Thank you. Good to see you and members of the committee. I look forward to a day we can do this in person again. Thank you for the opportunity to present Senate Bill 394. It has been my sincere pleasure to work with the Attorney General's office and other members attached to the GBI, et cetera, in order to promote this legislation. I'm going to give you a quick overview, and then we can talk about the couple specifics of the bill. Today, the Attorney General's office investigates with their counterparts in several different areas in order to bring folks to different areas of justice. But one of the areas that's very specific that I know we're all passionate about is to end human trafficking, as well as ongoing investigations for Medicaid fraud. So today, the Attorney General's office works very closely with the GBI, other local law enforcement, et cetera, in order to investigate, hopefully, and then prosecute the bad actors. In the law, though, the AG's officers need post authority, right? So a certified post police officer, if you will, in order to perform some of those tasks and functions. As an example, executing a warrant, court order, wiretap, subpoenas, the typical things they would do, seize evidence. So having that clarified in the AG is an important part for them to pursue those. Now, they have it in other parts of the law, but just not there. It really just clarifies what they can do. You might ask the question, well, gosh, why? Right? Why is this urgent, and why do we need to do this? Well, I think urgency, certainly, as we've made human trafficking a priority. Governor Kemp and specifically First Lady Marty Kemp with the Grace Commission are doing a lot of great work with pushing that forward. And it's obviously something that's critical timing when somebody is being potentially investigated and or prosecuted to make sure that we're protecting those that could be in harm. Also, it's hard when you're working with in concert with the law enforcement agency to kind of go back and forth all the time and not just be able to help out, truly help out. And I'll give you an example of that would be even in the Medicaid side, where if one of our local jurisdictions are involved, well, typically, I live in Roswell, right? The Roswell Police Department, which does a phenomenal job, the crimes and things they pursue are typically things like Medicaid fraud, right? So they're a little bit out of their area of expertise where they do a great job more in local community, where it makes sense more for the AGs to be able to help really push those things through. And they've been doing it in the past. So this is a way to clarify the law for what I believe will be a great way for us to prosecute and go after the bad actors in these crimes that are truly an atrocity as human trafficking is. So I'm going to then just kind of direct you to the bill, if I could, Senate Bill 394. It's not a very long bill, but it just defines what a peace officer is, right? And that means in Georgia, that's going to be a post-certified peace officer. And then it talks about the specific criminal cases that we're talking about that they will be able to use that authority under in order to execute the powers they will. I want you to know that I had talked to all the stakeholders in this back in the beginning of the year, certainly worked with Attorney General Chris Carr, Nick Smith, all the team there, but as well as the GBI and others, and they're perfectly comfortable with this legislation. They think it's the right thing to do, and I think that'll help us be more efficient and better at going after some of these bad actors. So with that in mind, I'll take a pause and be happy to answer any questions. And I do believe we've got some folks in the Attorney General's office on the line as well, that if we need their assistance, we can certainly perhaps call on them if that's appropriate, Mr. Chairman. I think both Nick and Hannah might be on.
Great. Thank you so much, Senator. All right. Are there any questions from members of the committee? I don't see any questions from members of the committee. I do see Mr. Lanier's hand raised, so I'll, Media Services, if you could please unmute Mr. Lanier.
Mr. Chairman, I just wanted to make sure, because of a unique situation we have now with the session, the effective date, we don't have one in this piece of legislation, so therefore it's dependent upon when the governor signs it. If it's signed after July 1st, it will not be effective until January 1 of the next year. I didn't know how critical it was to have this earlier. Do we want to make it effective upon signature? I would like maybe the author to express his thoughts on this.
Wow, that's a great catch, Jeff. Thank you. If it would please the chairman and members of the committee, I would like that to be the case. That would be good. And I'm going to look at Nick Smith as well with the AG's office, and I think he's shaking his head as well. So we would appreciate that. And I know you're going to have your full committee meeting, I believe, early next week. If we could maybe add a very simple amendment to that, that would be wonderful.
Okay.
Thank you for finding that.
Thank you, Mr. Lanier. Great point. Any other questions from members of the committee? All right, I don't see any. I know that Mr. Smith, I can see Mr. Smith is here in the meeting, and if Media Services would please unmute Mr. Smith just to provide any comment from the Attorney General's office or any or to recognize any other witnesses that that he thinks could help the committee with this bill.
Hey, good morning, Mr. Chairman and members of the committee. I want to thank y'all for taking the time to take this up. Senator Albers hit the nail on the head with the explanation, and Ledge Council, we'd be very appreciative of that correction once next week, because that is kind of the thought and the gist of what we want to do, is for this to go into effect immediately, so that the work that most of our attorneys and our unit are already doing can go into effect immediately. So I have Hannah, who's the head of our human trafficking section, Jim on the call as well. But I think we've done a great job kind of, outlaying, the concept of what we're trying to do. And right now I don't have any further comments, but we're very appreciative of that catch too with the date.
All right. Well, thank you very much for your being here, Senator Albers. Thank you, Mr. Smith. And what we'll do is ask Mr. Lanier if you could work on a substitute that includes the upon signature, effective upon signature. Then this bill will be ripe for consideration by the committee early next week, and we'll get notice out for when that meeting will be.
Okay.
All right.
Thank you so much, Mr. Chairman.
Great. Thank you very much. Thank you, Senator. All right.
Thanks,
very good. We'll now move on to our other bills on the agenda. We'll next call Senate Bill 272 for a hearing. And I see Senator Robertson's on the video call here. If Media Services would please unmute Senator Robertson. We will just ask if he would please give a brief summary of the bill and anything that he wants to say about it. And if members of the non-civil committee want to use the raise hand feature, then I'll recognize you for any questions. Senator?
Thank you, Chairman. I greatly appreciate the opportunity. Senate Bill 272 is a very brief piece of legislation, and basically what it does is it manages the distribution of products that contain dextromorphin or DXM. And what this is, it is a derivative of morphine that is placed in a lot of products, primarily cough syrups and sleeping medications. And the industry that distributes this and the retailers that provide it to the citizens have some concerns that underage individuals have been coming into their businesses and purchasing this and using it to mix with other substances such as certain types of athletic drinks and other things in order to get high and to get intoxicated. Studies dating back to 2004 up until today have shown increased emergency room visits with teens who have overused this product. And so what Senate Bill 272 hopes to do is just require that ID be shown. Working with the retailers, we think it would be have a negative impact to their margins and operations if we were to require all these products to be moved behind the counter like we did during the epidemic of meth, where we had to have all those moved back. It would put in starting penalties for those and business owners who repeatedly possibly let this go without the ID being checked. Those sanctions are not extreme, but I think they're to the point to where we could limit this and also limit the civil liability that may be experienced by some of these retailers here in Georgia. That's a brief explanation. I have the legislation in front of me. I'd be more than happy to go into any detail if any of your committee members have any questions. And again, thank you very much for giving me the opportunity to offer this legislation to your committee.
Thank you, Senator. Call on Vice Chairman Reeves.
Am I unmuted? Can y'all hear me?
We can hear you.
Okay, great. Thank you, Mr. Chairman, and thank you, Senator. I had spoken to the chairman before the hearing today and wanted to talk about my thoughts on the structure of this bill. And I think that everybody on the Judiciary Non Civil Committee knows that for 6 years now, I have been campaigning against this concept of civil penalties. And there is precedent in our law for the concept of civil penalties, but I do not believe, as a practicing lawyer who does criminal work and a great deal of civil litigation, I don't believe that civil penalties are constitutional or legal, because there is no service of process involved with the judgment that would force somebody to actually pay. And so I have waged heavy war against civil penalties for the last 6 years. And it's one of those things that, frankly, I think we need to go back through the entire code and remove them all, but that's another issue for another day. So I've done a lot of thinking through this bill, Senator, and I think that something that I would like to see discussed, and I certainly would like your perspective on this, as well as the perspective of the rest of the committee and anybody that's interested, is to, we have all kinds of misdemeanor criminal penalties throughout the law for things that we don't necessarily look at as, that are more of almost like an administrative misdemeanor. And in looking at this legislation and looking what we're trying to accomplish, what I would like to see is to remove the civil penalty aspect from the whole thing and to replace, as it relates to the retailer, create a misdemeanor offense for a retailer that violates this, or retailer or distributor. And I also am not opposed, and I think that it might be in the best interest of what we're trying to accomplish, to remove the penalty at all, civil penalty or misdemeanor penalty against the minor, unless they are distributing, selling, or trading it to other minors, if that makes any sense. I think that by doing this, we're really honing in on the key to this, and the key to this is the over-the-counter purchase. I think it's creating an even greater deal of accountability to the retailers by having the criminal misdemeanor offense associated with it. And we're also applying that same logic to a minor who seeks to distribute it to his friends or his or her friends or whoever else it may be that they are trying to distribute this to. So I think it accomplishes the goals of what we're looking to accomplish in a way that, to me, would survive constitutional scrutiny. I don't know when, and I don't know, I may be wrong, but I wouldn't be surprised if someday this concept that we have put into law of civil penalties in criminal code is struck down. And I believe that doing it this way will avoid this piece of legislation from being subject to that. And I think it helps greater achieve our goals. And I've been busy lately, Senator, so I wish that I should have called you and kind of given you my rundown and thoughts on this ahead of time. And I apologize for not doing that. And I'm not trying to commandeer this bill. I just think that this is a better way to do it, and it eases something that I have a lot of concern over with this concept of civil penalty.
And if I may respond.
Yes, please.
I absolutely have no problem with that. I do understand. I think the pandemic has put us all extremely busy in other areas and looking at things. But as far as the civil penalties went, the biggest input that came in on the civil penalty side were from the retailers who were concerned. I am a huge believer in due process. Civil penalties is certainly not a hill I'm willing to die on. And as far as having a solid piece of public safety legislation that is defensible under a challenge of its constitutionality is much more important to me than somebody trying to say they're commandeering or anything like that. I believe your intent is solid and pure, and I think it's right along the lines mine are. So I have absolutely no problem with looking at that. I think having it as a misdemeanor offense where a minimum and a maximum, and allowing the court to determine where the penalty falls. My only concern is, as with underage purchasing of alcohol, I think that there must be some responsibility held by the individual who does attempt to purchase it. But in this situation, I think the vast majority of the responsibility will definitely fall on the retailer, who is obligated to check the ID of the individual who's trying to purchase it. So I think the biggest impact on this will be to the retailer as opposed to the juvenile who may be coming in and attempting to purchase it. But I have absolutely no problem with working with you to continue making this legislation the best it can be. And if that means getting something done this session and getting it through, that's fantastic. And if it means parking it and starting over next session because of how important it is to me, and I think how important it is to the community, I have no problem with that either. So look at everything through the lens of public safety and smart legislation.
Am I unmuted, Mr. Chairman? Y'all can hear me. And as we're talking through this, something that, and I'm not, I would like to figure out, and I certainly will be willing to do what I can to help address. I think that it would probably be, in light of I can understand that the retail association would have concern about this. And I think that something that we might want to look at is figuring out how to create some factor that if the purchaser presents a fake ID or something to that effect that allows them to purport to the retailer that the retailer believes that they're of age, I think that that is something that we also need to look at, so that they're not caught in a situation that they're really, they acted in good faith and did everything on their part that they were supposed to do. And so I think that we would need to address that. And I think that I can work with Mr. Lanier and you and the committee and figure out a way to try to craft that language. And so I don't just offer these suggestions, and I'm not saying go figure it out. I'm more than willing to help and do what I can to make sure that we get this right. And I appreciate your interest in this and desire to make sure that we get something done and that's going to work.
All right, thank you. Representative Kendrick.
Hello, can everybody hear me?
Yes, we can hear you.
Okay, good morning, everyone. So I just wanted to ask a clarifying question about lines 28 and 29 with respect to minors. So Senator Robertson, could you, and you might have already mentioned this in your opening remarks, so this particular controlled substance is found in legal, is a part of legal substances, correct? Like I think somebody mentioned cough syrup, or I saw somewhere that it might be a part of cough syrup.
Yes, ma'am, that's correct. It's a counter. It's included in those, much like some of the reagent products that are used to make other illegal drugs like meth and things of that nature. It falls into that same category in a broad scope.
So is it possible, because of the language of 28 and 29, that a minor could purchase something like cough syrup and still be liable under this bill? I guess to follow what Representative Reeves was talking about, it seems like if this is a part of finished products such as cough syrup or other items that are as a whole legal, we're making it unlawful for a minor to purchase even things that are illegal. So I don't know if there is a way to say if they, to Representative Reeves' point, they show a fake ID, or to say that they distribute it or they use it in some illegal way. But I'm not sure if it's your intent of the bill to make it illegal for them to purchase substances who are on their face legal.
Right, and we already have legislation that helps the retailers if individuals come in with fake IDs. Luckily, our court system realizes that if there's no intent by the retailer to sell this to someone who's not supposed to have it, that the retailer is not charged. Same thing happens in alcohol sales. And also, we already have this kind of structure built in for certain types of adhesives, airplane glue, if you will, and things like that. If you go to Tractor Supply, they will ask for an ID, and you have to be a certain age before you can purchase it. So what it does is it does prevent minors from purchasing things that may be harmful. That in the situation with the glue, when my son was a teenager and needed it, I was required to go and purchase that for him. So yeah, it's exactly what you say it is, but there's already precedent throughout our community where certain items require an adult to go in and purchase it.
Ms. Chairman, can I ask just one follow-up question?
Please.
I know ignorance of the law is not a defense. I'm just worried because it's so common in just normal things that a minor might unsuspectedly go to purchase something that's innocuous and be subject to violation under this law. And I'm not sure, I'm sorry, I'm not sure if I've missed it somewhere where, you know, there has to be some type of intent to use it in a bad way in order for them to be liable under this bill. I'm just concerned that they're going to get caught up in purchasing normal things that happen to have a small amount of this because it says containing any quantity, and get caught up in this bill. And hopefully I'm explaining my concern correctly.
I think I understand your concern, and I think in most of those situations, like anything else with the glue or anything else, if a person unknowingly comes to the counter with one of these products and sits it up there, and the retailer asks for the ID, and the individual shows a license that shows them to be 16 years old, then the retailer would advise the individual that according to Georgia law, they would not be able to purchase that, and that they would need an adult to purchase it for them.
Thank you.
Representative Setzler.
Thank you, Mr. Chairman. Can you hear me okay? Okay,
Yes, I can hear you.
thank you. Senator Robertson, how are you? Appreciate you being with us today. I would, before I get to my main point, I would share, some concern that Representative Kendrick raised with respect to, we've seen things in the past where the intent with which the General Assembly passes a law and the reality with which local governments or local entities feel like their hands are tied and not being able to exercise any discretion because, well, the law says you can't this and that. I do think this committee needs to sort through those circumstances. If we desire that any product that contains this be unavailable to people under the age of 18, we need to understand and own that outcome. And that's in essence what we're doing in this bill. If that's the stated objective, let's say it, let's talk about it, let's own it. But we've seen circumstances with the no faults policy for weapons on campuses. We've seen kids with utility knives in cars that are intended to cut people out of car accidents. We've seen kids literally handed over to the police in Cobb County schools because the legislature didn't draw out the potential detail of what no blades longer than 2 inches on school campuses could possibly mean. And it was actually played out to its logical conclusions. I just think we need to, I'm not speaking on either side of the question, I just think we need to make sure we know if it says of any amount, we are in essence perhaps passing a prohibition of people under the age of 18 buying products that have any trace amount of this. I just think we need to say it. And if that's your intention, that's fine. I just want to make sure that we don't sidestep that question. So that's just sort of a parenthetical remark that we need to make sure we're thoughtful of. Secondly, Mr. Chairman, I don't know if this is directed to council or to Representative Reeves, Vice Chairman Reeves, on the issue of civil penalties and due process. If the civil penalty is the remedy that's teed up, and presumably these are civil penalties that are hanging out in Title 16, Representative Reeves, in existing law, is that correct? That being the case, is there any difference in due process if the remedy is a civil penalty than if there's a misdemeanor remedy? Do you have innocent until proven guilty? Do you have all the due process protections we have when a criminal statute's invoked if there's a civil penalty remedy, or is it something different? Perhaps that's a question to council or to Vice Chairman Reeves.
Can y'all hear me? They're totally different things. A civil remedy would come from essentially a judgment, which is and you cannot initiate a civil action that leads to a judgment without either service of process or an acknowledgement or waiver of service of process. And the standard, for any civil matter, the burden of proof is obviously proof preponderance and not proof beyond a reasonable doubt. So they're totally different. And I don't know, I have no idea what happened the first time this conversation came up or where the idea was brought over from. But I've always been concerned that this is subject to a constitutional challenge someday. And I do civil litigation for a living, and you can't, if you don't have a service of process, then you can't get a judgment. civil penalty is essentially a civil judgment saying you got to pay this fine, but there's no service of process. And I think it's a huge issue. I think I've made that clear, but yeah, they are not at all the same thing.
Well, and I asked the question, Vice Chairman Reeves, Mr. Chairman, if I could. I just want to be clear for the committee. The service of process issue is a serious one, something that needs to be obviously managed appropriately if that's going to be the avenue. But even that seems somewhat wonky and procedural when compared to due process that you have under criminal statutes. Now, folks would perhaps say they'd prefer to be subject to a civil penalty because there's not, quote, criminal responsibility tied to it. But there is a respite in criminal responsibility in as much as being proved beyond a reasonable doubt and having all the due process options available to you. It is more robust than the civil side. And I wanted to frame that both for the author and for the committee members. I wasn't sure how that played out, but you're saying the burden of proof is just beyond preponderance of the evidence, then if the civil penalty is the remedy, is what you're saying.
If you look at it through the eyes of through the spectrum of what it is, which is a civil judgment, I think the problem of this is that there's a real gray area where we're trying to take a civil judgment and kind of force it into criminal code. And I'm not sure that it's clear what the real burden of proof is on a civil penalty as we've defined in Title 16. And if there's any in Title 40 or wherever else through the code section, this may appear. But I know that we dealt with this issue a couple of years ago when we were dealing with the school bus camera matters, and I don't even remember what conclusions we came to on that. I know that there was a lot of issues with how that was gone through with the clerk's office and whatnot. But this is a real problematic area that, this isn't like this isn't the thing that's on anybody's mind more than anything else. But I have a lot of concerns about it. And I do not think we should replicate the concept.
Well, Mr. Chairman, I appreciate the Vice Chair's description. I wanted to frame these issues for the author, so his policy objectives are accomplished in this. So I think the question of trace amounts in conventional commercial products that we wouldn't want to prohibit a 16-year-old from purchasing is a question this committee needs to answer, and also the question of a civil penalty versus misdemeanor. I think those are the two things I see that we need to sort through. That's all I got, Mr. Chairman.
All right. It's been very helpful. We'll hear from one more member on this bill, and then I think there's been a lot of helpful input that's been given where members can either speak directly with the author or can get with counsel to have questions answered or amendments prepared if desired. So we'll next hear from Representative McLaurin.
Thank you, Mr. Chairman. It's good to see everybody, Senator. It's been too long. I want to start by giving limited props, I think is the technical term, to Chairman Setzler for expressing the idea that the committee should acknowledge exactly, what this bill does and what its consequences would be. I think we have to recognize there's a significant liberty interest in, kids who potentially are pretty autonomous and don't necessarily have access to an adult at all times, being able to manage their own health care. If they have a driver's license and are able to drive a car at those ages, it would seem kind of strange that they couldn't treat their own conditions. And so I guess my first question for the sponsor would be, have we given any thought to a provision like some other states have where we allow the sale upon showing a valid prescription?
This medication does not require a prescription. It's a product that's contained over-the-counter medicine. And just briefly, this is an ID check. With the civil penalties, I have absolutely no problem striking those for those who have concerns. It's a full ID check.
So, and I recognize that that's the intent of the bill as it's currently written, and I also recognize that this is typically an over-the-counter medicine, but since we have the police power as state legislators, I just thought, could we create a mechanism like a prescription by which, again, an autonomous, responsible, self-starter teenager, and my understanding is, and tell me if you have different data, that maybe as much as 3%, 1 in 30 teens admit to abusing DEX, and so I guess my question is, if we allow most responsible teens purchasing cough syrup to at least take the step of obtaining a healthcare provider's written recommendation of some kind that they be able to purchase the medicine, would that be enough to allay your concerns about abuse?
Well, my numbers come from the Poison Center and from emergency room visits based on this product. 20 other states have already implemented this. I know on board just as others have, but I would think it would be encumbering, I think, to physicians. It's already an overburdened healthcare system, and to everyone else, that product that has because there's several other items on the shelf to use, and that's the focus of this legislation, is to address those that abuse this drug. Once we started closing down the field mills, people went to two different areas to satisfy their cravings, and that was to heroin and then to over-the-counter substances that could be converted into drugs of abuse, and that's what we've experienced with DXM.
Okay, if I could ask just one final question, Mr. Chairman. That question would be, do you have specific demographic data about kids who are abusing this? Because I have a concern that this bill, on the surface of it, looks as though it is trying to identify one type of drug abuse traditionally or in the last few years associated with one community, at least in the eyes of the sponsor or folks who are concerned about the problem, versus, you know, drug abuse by kids in potentially better off neighborhoods that doesn't get quite as much legislative attention. So I'm just curious about the demographics of the data, if you have that.
Sure, I can give you some generalization as far as the demographics. When I started in law enforcement a little over 32 years ago, your primary heroin user would have been an African-American man, probably late 50s, early 60s. And what you're looking at now with the field mills closing down is the average is a white female between the ages of 17 and 24. And those are primarily the same groups you see abusing these types of medication. And I do want to point out that the vast majority of cough syrup that you can purchase in your local pharmacy or Publix or wherever do not contain this substance. But no, this legislation or any other legislation that I have is not targeting a specific demographic. It targets a specific behavior.
Okay, thank you.
All right, thank you, Representative McLaurin. All right, well, I want to thank the committee members for their engagement on that bill, and it looks like there are some very clear questions or areas to look at going forward. So that's the whole purpose of today, to identify those, and that's outstanding. Thank you all for your work on that. All right, at this point in time, we'll call Senate Bill 208 for hearing. What I'll do is attempt to just give kind of a summary of the overview of the policy that's really been outlined here, and then we can, and then I'll ask Ms. Doldy with Legislative Counsel's Office to walk us through the language of the actual bill. So, as the committee members recall, last year the Elliott opinion was released while the legislative session was in, and there were several bills that were put forward to address the Georgia constitutional issues with a little feedback here, if you would. Yeah, thank you. So the implied consent legislation then resulted, and Senate Bill 208 was one of those. The House Judiciary Non Civil Committee heard testimony from Mothers Against Drunk Driving, as well as many different organizations, and have held multiple hearings on the issue of driving under the influence and public safety and how to make our roadways safer. And consistently, we heard about the use of ignition interlock devices in approximately 34 other states currently is required for a DUI sanction or as a means to have a driving permit after a DUI. And so that really was the genesis of a lot of the conversations about the need for a potential requirement for a ignition interlock device. And committee members recall we actually saw one of those devices, as well as the facial recognition camera to attempt to identify the person going into the device. Thank you. And so what I think you'll see reflected in the substitute, the House Bill 208, are two general policy concepts. The first is that in order to address a limited driving permit for a suspension that results from a DUI conviction, there would be an ignition interlock requirement that would be part of that. And I'll defer to the sponsor and others on this, but it's my understanding that the limited driving permit right now does not have any requirement necessarily to use an ignition interlock device. And so there's no way to verify or check whether a person is driving under the influence of alcohol while using one of these limited permits. There also are a limited number of permitted places to drive when you have the limited permit, and that's very difficult to verify as well. The second policy discussion here for consideration in Senate Bill 208, broadly speaking, is the potential availability for diversion in a first lifetime DUI case. So my understanding is that diversion is available in certain jurisdictions through a DUI accountability court for a third or subsequent DUI, but it's not available for a first lifetime arrest. And so that concept is outlined toward the end of the bill that would carry very significant conditions and would be allowed in only limited circumstances, but would allow for that and would be available if a person charged wanted to really demonstrate through very strict and difficult conditions that he or she is deserving. It's important to note that that diversion would only be available if it's offered by a solicitor or a DA. And so it's there's no mandate in the law for it to be offered. And also it would not in any way undercut the existing requirements that a solicitor might have for conditions in order to enter into the program. So if there were to be a certain waiver that's required as part of the agreement, nothing to my knowledge would prevent or prohibit that use. All right, so just giving kind of an overview of the bill, of the policy objectives here. I know that the law is very complex, and we have received input from many experts in this very important area of public safety for our state. And what I'd ask Legislative Counsel now to do is to just walk us through the actual language of the bill. One thing that I forgot to mention was there has been some input given about this substitute, and the input has been, well, there are other areas where a limited driving permit should be available, such as for DUI drug offenses. And I think that what's important to note is there is legislation out there where the General Assembly is considering that, specifically House Bill 799, I believe. But this bill is only intended to reflect the current state of law. In other words, an update of these policies to the existing state of law. And so I would, just as kind of a preamble to our discussion today, say that we acknowledge that this is going to be a long discussion, that we're going to be able to receive a great deal of input going forward. But I think getting this in front of the committee members at this early stage before we begin session next week is a good thing. So at this point in time, Jenna, I would ask you if you'd be willing to walk us through the language of LC 39269S. Thank you.
Good morning. I apologize. It is 27 pages, so I'm going to try and go through it as quickly as I can. And I think the easiest way would just be go section by section. Starting on page 2, section 1, basically that section is going to remove the limited driving permit option for DUIs that were committed in another state. Throughout the bill, we are removing the limited driving permit option for anyone who has been convicted of a DUI. So obviously doing it for someone that got convicted in another state would mirror this there in section 1. Section 2 of the bill, we're in this code section, it deals with the period of suspension and how you can get your license reinstated during that time. Section A in current law of 40-5-63 has DUI post-conviction suspensions mixed in with 40-5-54 suspensions. And in the bill, we're going to separate them out because they're going to come under different standards going forward. So basically, in A will now only be post-DUI conviction suspensions. And for the first DUI conviction, it will be a 12-month suspension. There will no longer be an early reinstatement option after 120 days, which is current law. If you want to drive or operate a vehicle during that time, you would only be able to do so with an ignition interlock device on the vehicle and obtaining that permit. The reinstatement would be the same, although there's a lot of language stricken here. The price to reinstate is the same, which is $210 or $200, and you would also still need to take that risk reduction course. So if you didn't use the ignition interlock for the 12 months, you just wait it off and be eligible to reinstate after that 12 months and paying the fee and the taking the class. And you'll notice on line 86 through 87, this concept is used throughout the bill. It's basically saying that if you've used that pretrial diversion program option, which we'll talk about at the end of this, the specifics, that's going to count as a conviction. So if you use that at any point, you would no longer be on a first DUI, you'd be kicked off to the second. Line 96 is where we start talking about the second convictions for DUI. So it would be now an 18-month suspension of your license. Again, no early reinstatement option. And if you want to drive during those 18 months, you have to have the ignition interlock device. And to reinstate after the 18 months maintains current law of paying the fee and taking risk reduction. And again, the pretrial diversion on lines 128 and 130, that talks about if you took the option of pretrial diversion at any point in time, it's counted as a conviction for these purposes. Lines 131 on talks about third convictions, and those are basically considered habitual violators at that point. We're not really doing anything to that, except that, again, pretrial diversion would count for kicking you into a third conviction purposes. So the new language on lines 146 through the rest of this section are essentially taking out those 40-5-54 suspensions that were in A and making it its own code subsection. And just for your reference, the suspensions or the offenses for 40-5-54 suspensions are homicide by vehicle, commission of a felony with a vehicle, hit and run, drag racing, fleeing police, and driving while under suspended license. So this doesn't change the current policy for those. It's just clarifying that if you have been suspended for a conviction of those, you would still be allowed to reinstate after 120 days. So it just makes it clear that those are still being eligible for early reinstatement, but no longer a post-conviction DUI would you be eligible for early reinstatement. So on to page 6, on section 3, this is all dealing with limited driving permits. And so again, we are removing, in this section of the bill, you're gonna remove all of the limited driving permit option for any post-conviction DUI. So basically, limited driving permits would only be available now to points offenses, those 40-5-54 offenses I just spoke of, a pre-conviction DUI if you submitted to the test, and under 21 conviction for certain dangerous offenses, and over 18 certain speeding offenses. So no more post-conviction DUI for limited driving permit. 242 through 246 of the bill, we're striking that language. I believe this is an issue where a couple years ago we had two bills traveling at the same time that dealt with this code section. It was criminal justice reform and also the pre-conviction ignition interlock bill. And since one was passed after the other, there's some overlap that had to be added back into code, even though that wasn't the intent, but because they both conflicted, that's what happened. So that's being removed there. Again, that happens on lines 258 to 259. Lines 262 and 263, again, no limited driving permit for a post-conviction DUI. Move forward to page 9, section 4. This whole section is dealing with ignition interlock device limited driving permits. And so throughout this whole section, we're going to be adding in that for your first conviction within 5 years, you can get that ignition interlock limited device, limited driving permit. And let's see, so lines 327 to 331, again, you're adding in that first DUI conviction. It mirrors what's on current law for the second conviction. And we're removing that 120 days in line 336 to 337 because it will be available immediately versus right now for a second DUI, you have to wait the 120 days before you can get that limited driving permit with an IID. This one would be available as soon as you are convicted. You wouldn't have to wait anything out. On page 11 is just talking about how you can go about getting that ignition interlock device limited driving permit. One of the ways will be that the prosecutor will submit something saying that that a person is a participant in that pretrial diversion program that we'll speak about later. Or also the court can show, you can have evidence from the court that you've been convicted of your first DUI. It does keep the concept in here on lines 380 through 383 of financial hardship waivers. That has not been removed. But if you get a financial hardship waiver, you are not eligible for any kind of permit or driving for 1 year. 396 through 418, we're taking out all of the restrictions that are currently in for ignition interlock driving permits. So instead of saying you can only use them to go to the hospital, you can basically use it immediately and you can drive where you want as long as you have that ignition interlock device on the vehicle. And then on lines 424 through 427, we're clarifying that an ignition interlock device permit doesn't get revoked if you get convicted of the same underlying DUI charge. And 446 to 449, you can also, we're now adding that the permit can be revoked upon notice from a prosecutor that you are no longer, or a person is no longer participating in the diversion program. So if they drop out for some reason, then the department can now revoke that permit and the ability to drive with the ignition interlock device. Section 5 of the bill on page 14, this section talks about the time an ignition interlock device permit counts towards any post-conviction suspension, and for the same offense, of course. And so that's on lines 486 through 491. So basically anytime you're on your ignition interlock device permit, and it'll count towards your post-conviction. And then lines 492 through 497, we're taking out limited driving permit options for DUI convictions there. Section 6 of the bill, we're just moving this is sort of cleanup, moving these two code sections under the same article. I think it's just, there's no cross-references to that article being separated out. I think with some of the reforms over the years, it just has stayed there and doesn't necessarily need to be in that article anymore. Section 7 of the bill is which courts can issue an ignition interlock device permit or revoke it. And so you'll notice on lines 533 through 544, it's basically saying that if you're The court that has convicted someone of the DUI can also issue those permits. So this would be in addition to the current law of DUI courts and mental health courts you'll see on line 512. Those are the current courts that can do that. So we're adding any court that actually issues you the conviction can also issue the permit or revoke it. So then we move on to Section 8 of the bill, and that's just a little bit of cleanup as well. We're moving an exclusivity of a code section. That article, there are other code sections that we're amending that are not in the article of exclusivity. So taking that out, make sure that everything that we're saying in the rest of the bill actually goes into effect. And Section 9 is the DUI code, 40-6-391. So basically, again, throughout this this section of the bill, we're going to say for sentencing purposes, pretrial diversion does count, or participation does count as a previous conviction. So again, if you participated in pretrial diversion and then got a second DUI, it would be considered your second DUI. You're not getting away with that being your first. There is a policy change on line 592, which was changing the period of imprisonment for a conviction of a first DUI from 10 days to 24 hours, but no more than 12 months. And so this section here, 592 through 601, is partially a cleanup because it's clarifying that your sentence of 12 months can be probated, because for some reason we have that language in the second and third DUIs, but we never had it in the first. So that seems like it would be an overlook that obviously the sentence can be probated. But then it's also making this concept of ignition interlock devices, instead of a part of the sentencing and punishment of a DUI, that it would be more of a condition of probation. And I'll get into that when we get to page 21 a little more, but it's basically that instead of a sentence, a term of your sentence, it is a probation condition. And so that sort of goes throughout all of this section 9. So we do the same thing about pretrial diversion counting as a conviction, and also that that it's a request versus sentencing, a request of probation versus sentencing throughout all of 17, 18, page 19. Because those are all for all four and subsequent DUIs, we're doing that. So then on page 21 is where we get into, again, this concept that for a first conviction or subsequent, instead of saying that the ignition interlock device is part of your sentence, it is now going to be, if a probationer wants to drive during that period of time, that they would request that they get this IID condition of probation, and it would mirror the period of suspension. So for your first, it would be 12 months. For your second, it would be 18 months. And so if you want to drive at any point during your suspension period, the court would say, yes, that's part of your probation. You can do that. But it would be upon the probationer's request and not necessarily your punishment for conviction. So therefore, if you don't drive, if you move out of state, then you would just not make that request. So that sort of goes throughout all that. And then again, the court on like 784, the court can modify this condition. So if you, for some reason, decide you don't want to drive anymore, then they can take that off of your condition of probation. Line 803 is just cross-referencing to say that time served on your ignition interlock does count towards your suspension time. Section 11 of the bill, which starts on 816, is basically the length of the ignition interlock device permit, and timing will coincide, and it coincides with changes elsewhere in the bill. Section 12 is adding a first DUI for when you're violating the ignition interlock permit, because again, we're adding first DUIs to everything. So that has to go throughout the bill. Section 13, again, adding the cross-reference to a first DUI for ignition interlocks. Section 14 of the bill is a policy change On line 882, this is basically saying that you would be required to be in jail for 24 hours upon a DUI arrest, and that would be matching what we're doing in the 391 change. So it would go from 6 hours after booking to 24. Lines 884 on for section 15 is a cleanup for the definition of an IID provider. And then 16 is the heart of the policy change as well. For section 16, we're talking about this pretrial diversion program for DUIs. And if it's your first lifetime DUI, you would only be eligible for these programs if you had submitted to the test and blew less than 0.12, or if it was a drug-related DUI, you had a prescription, a valid prescription, and you were using it as authorized. And then you'll see on lines 909 through 919, these are the different things that you have to do if you're going to participate in this program: the risk reduction, a period in jail, and it's a 12-month program, 100 hours of community service. You have to do the clinical evaluation and also have ignition interlock for 6 months. Lines 920 through 923 specify that the participation in this does not allow you to have record restrictions. So hopefully that will alleviate any concern that this could impact funding and CDL or commercial driver's license issues, because it would still be available to anyone. It's not record restricted. And the effective date is January 1, 2021.
All right, so we'll next hear from Senator Robertson and members of the committee. If you would use the raise hand feature, then we will go to each of you after that. Senator.
Thank you, Mr. Chairman. Repeat what Legislative Council just went through, I think in a very, very well manner. But again, this is another thing to address the issues that we have related to public safety in Georgia. DUIs, people operating motor vehicles while under the influence of alcohol has not gone down throughout the years, and there have not been enough sanctions in the place to protect the citizens that travel up and down our roads. A lot of times the temporary permits that are currently being given aren't necessarily being able to be enforced by law enforcement, because sometimes they regulate that an individual can only drive to school or to work. And a lot of these adults are going to colleges or technical schools, anywhere from that open up at 8 in the morning and some that run until almost midnight at night. So when officers stop these individuals and see their temporary driving permit, it's pretty much what the officer is told at the time that he or she must basically take as the truth and allow this individual to proceed on, even though they may be in fact violating. And also there's the temporary driving permit, especially those that are only allowed for school and for work, impact the individual with the driving permit, that they can't do other activities that other citizens of Georgia can do that do not involve drinking alcohol or driving. Such things related to health care and others maybe to move about and be productive citizens. And with that, I'll yield to listen to the comments of the committee.
All right, what we're going to do now is we'll hear from Representative Momtahan if he has a question or comment. And then what I'll do is I will call on, okay, we'll hear from Representative Momtahan and Setzler, but then I'd ask other committee members. All right, everyone's popping up here. So why don't we do this? What I'd ask to do is to hear from any members that want to make comments at this time. And then if we could hold on any questions until we hear from the Prosecuting Attorneys Council and the Georgia Association of Criminal Defense Lawyers, then we can, it's possible that any questions will be addressed in their presentation. So we'll go ahead and hear from Representative Momtahan now. So Representative Momtahan, you will have to click the 3 dots by your picture and click unmute.
All right, can you hear me?
Yes, we can hear you.
Okay, fantastic. Thank you, Mr. Chairman and Senator Robertson, for bringing this bill. Very important issue to our state. You know, in this committee, we have gone time and time again talking about, you know, how DUIs affect our communities, how they affect our families, and just people that are hit or killed by these offenders. So I appreciate the fact that we are really taking a deeper dive at this issue and seeing how we can come up with really anything that'll help tamp these down. That being said, I do have some concerns. I wanted to kind of go through that. So I see that in different sections, we are lowering the amount of time for the suspensions down. I think in line 81, or maybe I'm wrong there, it looks like we're lowering it from 3 years to 18 months. And I don't know, Mr. Chairman, do you want me to go?
I think what we could do is, Ms. Doldy, if you could be unmuted, is that correct? Is the period of suspension being reduced?
Yes, it is, because as we discussed, that we're no longer allowing them to be eligible for early reinstatement. So essentially we're mirroring that to the early reinstatement time. So instead of sort of a fiction, I would say some people would call it, that it's a 3-year suspension because they can reinstate after 18 months. So now it's just a hard 18 months. You can't get anything early. It's just doing what most people are doing now as a hard suspension that you'd have to age off.
So as I understand it, the letter of the law is changing to reflect a reduction, but in practice, it would not be an actual reduction of time.
I mean, I guess in certain instances, there may be plenty of people that don't early reinstate. I wouldn't know the figures on that, but you are eligible to early reinstate after 18 months. So I believe your intent was to make it to mirror sort of what's going on in practice for the majority of offenders. Okay,
thank you. All right, Representative Montana.
Thank you, Mr. Chairman. Yeah, and obviously I have some concern with that. When we're talking about offenders or multiple offenders, you know, we want to make sure that, you know, that these penalties are, you know, they equal the offense. And when we see the amount of these traffic fatalities from these DUIs, I think it may be important for us to take another look or a deeper dive at that. The next one, and I know this, I'm pretty familiar with the 391 code section.
Representative Montana, if I could just interrupt you on that first point with your concern, do you believe that the 3-year suspension should then be a hard suspension and should not be, an early reinstatement should not be permitted after 18 months because of the concern that you're expressing there?
Well, and it goes back to offender status, right? Statistically, when we look at offenders, you know, they cross the threshold from being, you know, a first-time offender to this multiple offender status, right? Whether it's multiple times between 5 years or 7 years or more, we know what the statistic probability of them to reoffend is. And so, you know, I understand that we're trying to attempt to put in place more restrictions or potential outlet for these folks, but I want to be sure that, you know, I guess my concern would be that we're presenting this as a magic bullet, right? When really treatment and the healing of communities or individuals or families starts with a confluence of different things. And so when we talk about, just in my professional scope, as somebody who administrates these kind of rehabilitation programs, you know, we see things like, you know, clinical evaluations, ASAM level 1 and 2, which is, you know, multiple weeks of treatment and therapies where people can come in and talk about the issues and talk about their families. We look at some of the faith-based, or we see some of the non-faith-based groups. One faith-based community group is called Celebrate Recovery, has great results. Another one would be—
I'm sorry to interrupt you, Representative Montana. I guess as you and I discussed before the committee today, I don't think anybody's proposing that Senate Bill 208 will categorically end offenders from committing these offenses, or that it's the silver bullet solution to everything.
Sure.
My question was about the issue that you raised, that there is a 3-year suspension that is not being, I guess, followed by people who are seeking early reinstatement currently. And you have a problem with the language in Senate Bill 208 with respect to that. So just specifically on that, what are you proposing should this bill should have with respect to that? Should the 3-year suspension be a hard suspension? Should the law be left unchanged as it is right now, where reinstatement could be sought after 18 months? Or are you recommending something else?
Right. So I would be more in favor of a hard suspension for multiple offender. You know, we want to make sure that we are giving those folks the time, right, that's needed to re-earn those privileges, whether that means going through these multiple types of treatments or finding community partners that will help them to be rehabilitated to potentially stop these kind of heinous acts.
Okay, that answers my question. Thank you.
If I may proceed, Mr. Chairman, I know that this code section is copied multiple times throughout 391, but I think it may be time to effectuate a change and put some discernment between the risk reduction program and the defensive driving. I think that would be a great cleanup. Again, line 161, and probably throughout that bill, the 26-page bill. The defensive driving class is more geared towards moving violations, running a stop sign, speeding, things of that nature, running a yield sign. Probably we don't want to allow somebody who's a multiple offender to take a simple 6-hour traffic refresher course to be able to use that for a early reinstatement or something of that nature.
Representative Momtahan, and maybe we can bring in legislative counsel at that point. It's my understanding that OCGA, the code section that we're dealing with here, 40-5-63, deals with driving offenses in multiple different driving offenses. And so defensive driving might be permitted as a course for some offenses, but that we're not saying that defensive driving would be permitted for driving under the influence offense. Ms. Doldy, am I correct?
Yes, you'll see on lines 77 through 80, Representative Momtahan, for the DUI offenses, you're only going to be eligible, you only can reinstate if you take the DUI alcohol risk reduction program. But if you have a 40-554 offense, which is those ones I listed out earlier, drag racing, etc., those could also, you could either take that DUI class or you could take the defensive driving.
Okay.
All right, Representative Momtahan, in light of that, I just want to confirm, do you still have an issue with this language?
No, sir. No, sir.
Okay.
161. If that is the case, of course, I'm reading it without the same kind of legal eyesight that you have. And I guess just to kind of cap off for sake of time here, I really appreciate the bill being brought forward by Senator Robertson. I absolutely agree with where he's going, and that there are needed changes to this code section. And I want to see that kind of holistic approach to making sure that folks have options. There's probably a little bit there could be a little bit too much of a narrowing here, where you're kind of boxing offenders in to effectively taking an IILS, which may in some cases be potentially too expensive for an offender, and not giving the option of having some of these more free or low cost community solutions. And so again, I believe in a confluence of different treatment factors that certainly heal communities, families, and individuals.
All right, thank you. I'll next recognize Representative McLaurin.
Thank you, Mr. Chairman. I appreciate the opportunity. I'll try to keep my comments to basically 1 or 2 minutes and just give an overview quickly of some of my main issues with the bill. I think that Gachtel and Pack are in all likelihood going to speak to a lot of the issues that I will raise, but I just want to flag really quickly what my areas of concern are. My framework comment would be that the bill appears to increase costs and restrictions for first offense on a theory that doing so categorically saves lives, but I feel like more restriction or costs also pushes violators to risk more, to find alternatives like letting a license lapse, driving outside the regulatory system. And it also moves away from a system in which courts can exercise discretion to rehabilitate and assess individuals on a case-by-case basis, which is something like the proposal I think both Gachtel and Pack endorse, which is conditional discharge as an alternative for a first offense. I think phrases like re-earned privileges or heinous, I recognize that DUI has substantial policy consequences and it wrecks families, but we have to be sensitive to the costs we're imposing and how high they go. I think in our minds, discretion should be synonymous with the word rehabilitation. And so we should do everything we can to give trial courts the tools they need. Quickly, 4 things. First, fees. A, no cap on fees. I think we should have a statutory cap to make sure that private industry can't adjust them after the fact. B, there's no provision for those funds to go to the state. I think we should make sure that they do. C, arbitrary denial of driving privileges to somebody with a hardship waiver. It doesn't make any sense to me why there's a wealth-based disparity in the way that the bill is drafted right now. Second, I mentioned conditional discharge. I think that Pack and Gachtel will call for that as an alternative. Third, there's several constitutional issues. First, treating diversion as a conviction. I think, and Pack will speak more to that. Second, and this is something that I raised, I think going to 24 hours of post-arrest detention raises a potential substantive due process problem. And the reason is, in the 11th Circuit, if you intend to punish somebody pre-trial, pre-conviction, that doesn't fall under 8th Amendment right, which is about excessive punishment, but it falls under 14th Amendment right to substantive due process, essentially the idea that they haven't been convicted yet. And so I worry that if there's no, and the test is reasonable relation to a government interest. So if there's not a legitimate government interest in detaining somebody for 24 hours, then I think we'd be vulnerable to a constitutional challenge. The 6-hour mark, I think, is reasonably related to ensuring that somebody's safe to drive and doing necessary testing. And fourth, finally, for now, the structure of the diversion program seems arbitrary to me. It doesn't make sense why IID would be required for non-alcohol violations, and the cutoffs for entry to the program just seem a little bit restrictive. But that's just a brief overview, and I welcome Pack and Gachtel's presentation. Thanks, Mr. Chairman.
Well, thank you, Representative McLaurin. I do agree. I think Pack and Gachtel are going to raise some similar issues, and these are pertinent areas for discussion. On the hardship waiver, if I could just ask you about that. Are you concerned at all about a statutory requirement that the IIDs are provided based upon a judge issuing an order? That's my first question, a hardship order. And then related to that, is your true concern maybe that a 12-month suspension by law as a result of a first DUI conviction is too excessive? Or do you, in other words, if reinstatement is available at a sooner period of time, is that really the heart of the issue, and that the 12-month suspension in existing law is too punitive? So those are my two. Yeah.
Thanks, Mr. Chairman. If I understand you correctly, I mean, it kind of seems like different ways to take a bite at the restriction apple, right? I mean, it seems like you're saying if my argument is that 12 months is too restrictive, and somehow that got brought down, that the other issue wouldn't be as pressing. I think, obviously, I'm operating under the global framework, like I said, that I think more restriction we need to be very careful about on a first offense, particularly when, repeat offenders, the number drops off substantially. DUI convictions are going down in general. But what I would say is, I guess I'll grant you some leeway on that in terms of my perspective, that there are probably multiple ways to make sure that the system is not overly restrictive for people for whom the public policy benefits don't necessarily track that restriction. That being said, I think when you have a statutory provision that explicitly creates classes of privilege in terms of whether somebody has access to that limited permit, and it's sensitive to income or wealth, I think that's on its face a problem. And so I wouldn't want to have a system where that were true regardless of what was mostly animating the public policy concern.
Okay. Yeah, there was another question there, but I'll reserve on that. We'll talk about that maybe offline. My next question would be though for you. I know you mentioned that there might be some constitutional concerns as far as use of the pretrial diversion as a basis for a subsequent enhanced penalty in what would otherwise be a second DUI. And I guess my question for you would be, do you see it similarly with a conditional discharge treatment where an enhancement would be available for a non-conviction previously? Is that yes or no on that?
Yeah, I mean, well, I'll say to the extent that any situation you're in where a jury has not found the facts necessary to enhance the sentence is a constitutional problem. And so I think it depends on how it works, right? If the second sentence, if the jury is not finding the facts necessary to give the judge that sentencing authority, then yes, it's a constitutional problem. But and I'm not as familiar with conditional discharge if that's already in place, whether how the system takes care of that problem. But that, I mean, if we have a problem in our law on that basis, we may already have that problem.
I see. I guess what I'm really getting at is other sentence treatment. So what we discuss is first offender treatment or conditional discharge treatment. That would not address the constitutional issue that you see with enhanced sentencing for a second, because the first did not result in a conviction. Is that
right?
fair?
I mean, I think it's fair to say if you are seeking enhanced penalties on a second conviction, the jury would have to find the facts necessary for the judge to issue enhanced sentencing on the basis of having previously committed the first offense.
Okay. Thank you so much. And thanks for being succinct and letting me ask some follow-up questions. Representative Bodie.
Thanks, Mr. Chairman.
And Representative Bodie, if you would just hit the 3 buttons by your picture and click unmute, we'll hear from you.
So thank you so much, Mr. Chairman. I want to say that I looked over the bill, and Representative Josh McLaurin has hit most of the major concerns that I have about the bill. First of all, we know DUIs are issue in individuals driving on the state roads that are driving drunk is an issue. I'm not going to say that it's not. However, I just look at the timing and the necessity of this bill at this point in time, and want to kind of hear from the author and anyone else in the room is why now? Because we already have pretty much almost mandatory interlocutory for individuals for their second DUI. First-time DUIs, the recidivism rate is about 33%. Also, the cost of first DUIs probably now about $12,000. I think in 2009 it was a little bit over 10. So it's probably $12,000 to $15,000, and I think that, on top of the I would say embarrassment of the defendants, losing employment, insurance rates probably lapsing. It's a lot of, I would say, reasons for an individual not to commit the second offense. Also, I have major concerns with the 24 hours in jail. Because a lot of times a DUI is still a misdemeanor. In some cases, definitely a higher and aggravated misdemeanor. But an individual should be allowed to post their bond when the bond is posted, and pretty much or when a bond is offered. And being that this is a misdemeanor case, most DUI bonds are posted as a jail bond, and so it's almost automatic, and the individual just has to bond out. Typically, DUI defendant may stay in jail pre-trial for 6 to 8 hours. And we know if it's the first in lifetime, they have to do 24 hours, and the judge can always mandate that they go back to jail as part of a plea agreement or a verdict of guilty. So I'm just I just think that we should tread lightly and be very cautious of some of the provisions that are in the bill. But we're here to work on the bill and vet the bill. But I'm just wanting to understand the necessity of right now, when I feel like the the stats do not show that we need to have mandatory interlocutors for first and lifetime DUI defendants. Thank you, Mr. Chair.
Thank you, Whit Bodie, and I completely agree with you. This is an opportunity to vet and really consider all provisions of what's a long bill here. And so thank you so much for your input. I know that the original notice said we'd go until 11:30. I'm comfortable with us going a little bit longer here today until noon to just hear from members of the committee and those witnesses who are here to give comments for us. So next, I'll recognize Representative Setzler to give us any comments, and then we'll move on to Pack and Gachtel and other witnesses here today. Representative Setzler.
Mr. Chairman, members of the committee, I appreciate the debate. This is, and you're right to my friend Whit Bodie's question, why now? This is something, as the gentleman probably knows, it's been worked on with some level of detail since 2011. We really put this on the table as a legislature in 11. We've come close many times. I think without working through this as holistically as I think SB 208 attempts to do, we find the source of why we've not had a chance to move close to this already is not because of the policy question, but more to do with things kind of came unraveled because we're trying to take it just piece by piece and just insert the first offense interlock into an existing very complex statute. And I think the more holistic approach gets us closer to where we wanted to be. So I appreciate Senator Robertson's effort to do that. I would say parenthetically, I think the question of DUI drug is something this committee needs to not address this time, but it's something I think we need to address very soon. I came across a DUI case. There's an accident just driving home from work the other day. I think it's becoming more and more the reality that unsafe drivers are the result of marijuana and other drugs and not just alcohol, as is historically the case. I would say, though, the idea of why first offenders, I know Whit Bodie raised that question as well, that interlocks a reality for second offense and forward. I do think the ability to reform people, Mr. Chairman and members of the committee, with a first offense DUI with an interlock device, I think is a reality we can't ignore. I think the impact on a quote unquote ordinary citizen who's not been in the DUI system before, the impact of using an interlock device is a wake up call to them. I think it's something that will make sure they're getting their life back in track. And I think the reform and safety impact of an interlock for a first offender will be even more significant than we would see on a percentage basis on second and subsequent offenders, because these are more normal people that are encountering this for the first time. So I think first offense, I think the impact on first offenders on a case-by-case basis can even be greater. I would say one thing that matters to me, and I say this as a civil libertarian, I mean, I've always thought that it's government's job to both protect the public and protect the liberty interest of individuals. I do think, though, the fact that we're able to get people driving, not just in the limited driving permit set of circumstances, but driving more broadly, to be able to go anywhere and live your life, as Senator Robertson alluded to earlier, within the law, using the interlock device is a way better public policy outcome than trying to ask people to only go to work, only go to church, and sort of live the lie that that's the only place they're driving, when in fact they need to drive other places. I think this gives them, from a liberty interest perspective, gives them the ability to drive more places and live a normal life as they're going through this interlock regime, and as we would be framing it under the bill. Since it's time, Mr. Chairman, I won't go into a whole lot more, but there are a couple issues I would like to highlight. I will say the idea of the hard suspension for second offense DUI offenders of 120 days, that's always raised a concern of mine that people are going to drive uninsured without a license. This gives a mechanism for them to be able to be under an interlock regime, even for a second offender, to be driving, but to make sure they have a license that's they're insured drivers. They're not without licenses, which can endanger others by non-compliance. One thing I would raise to Representative McLaurin's questions, Mr. Chairman, the issue of cost. When you look at the economy of DUI and the cost of a DUI offense to individuals, it is not a cheap expense. From lawyers' fees to the cost of penalties. To me, the cost of the interlock device relative to the others can be woven into the overall regime of this in a way that may not dramatically raise the cost, but advances the public safety interest considerably. We've got the ability to work with penalty costs and those kind of things that are, or even court costs that are part of the DUI experience. And if we want to bring those down to make room for the increased cost of interlock, I think there's a public safety interest in doing that. There's a restorative justice in that the overall cost perhaps doesn't have to be higher, but the overall public safety benefit is dramatically enhanced, I believe. A couple questions, Mr. Chairman, I would like to ask just parenthetically to the author and perhaps for PAC to address. The first one was the record restrictions implications of this. I've been a big supporter of record restrictions in the past, and I don't know in reading the bill exactly what the implications are with respect to record restrictions. So that's a question I would just ask for PAC and GACTL to address. Secondly, the issue of diversion programs not being available to folks above a 0.12 BAC. I'm not an expert in this area of law. I know in the past it seemed that the threshold for more severe treatment has been 0.15. I don't know if there's a threshold at 0.12 in existing law, but I think if we're going to treat a 0.12 threshold as a threshold beyond which you couldn't get diversion, there needs to be consistency with that and other parts of law that look at a threshold. I thought there was a 0.15 threshold. I may be factually wrong about that, Mr. Chairman.
I believe you're correct. You're correct about that. And 0.12 is not an existing threshold elsewhere. So you're accurate, is my understanding.
I was just raised, perhaps if we're going to contemplate that as a policy, maybe there needs to be alignment with that. And then lastly, this question of interlock possibilities. I don't know by law if interlock can be ordered by judges for reckless driving offenses. But I think we all know that reckless driving is the final adjudication for many cases of people driving under the influence of alcohol. And do we provide a permissive means for judges to order interlock for offenses other than DUI at the discretion of the court if they think a DUI regime is useful in the life of the offender and bringing about a public safety interest? So I just raised that sort of as a question for the broader conversation. But Mr. Chairman, I appreciate your time.
All right, thank you very much, Representative Setzler. So at this point in time, we will recognize Ms. Travis or Ms. Causey with the Georgia Association of Criminal Defense Attorneys to just give us a brief overview. And then what I'll do is I'll ask members who have questions for them to use the raise hand feature. And we'll hear from PAC, and then we will give members a chance to ask questions of the witnesses. So if we would please unmute Ms. Travis and Ms. Causey.
Thank you, Chairman. We're really delighted to be able to present to you today and join this really important discussion around the expansion of the DUI code sections. We are going to focus most of our attention on the first offense DUIs, though we understand the prosecutors and other members have cited some concerns about the second and subsequent DUI implications of this bill. And we would start with the threshold matter around money that's been mentioned several times today. This bill imposes extensive and unnecessary financial burdens on all drivers, basically by removing the opportunity for that limited driving permit that we have today and requiring the installation of an interlock device. If the programs and tools that are offered to folks who are facing DUI convictions are not affordable, you will not see an increased compliance with them. And we would expect also litigation to rise as people balk at the idea of having to use these programs and tools, despite the public safety enhancements that are driving the policy behind this bill. We have provided the committee with an outline of our major points, and in that we dive into a lot of the details around the cost. So I won't belabor that issue here. I hope everyone received that, and we certainly would redistribute it if anyone did not receive it. But the costs that have been mentioned on the call today by other members are in line with what we see with respect to both the current situation and the addition of an IID. We would also want to say that to Chairman Setzler's point, that there is, judges are able, on reckless, I actually don't know the answer to that, I'll have to check, but judges right now today can require IIDs to be installed on the cars of first-time offenders in the DUI context, and they do that. The recidivism rate for first offender is about 33%. So there's another 66% who are not showing up again in court, and the judges are in the best position to make those determinations based on the facts of the case. In addition, just to address a couple of other, I'll just take them in turn. So what you'll see, we provide some proposed amendments that actually are in line with some of the things that Chairman Setzler was saying about finding ways to reduce the overall cost if you were to move forward with this IID idea. For instance, reducing the fine for a first offender, putting a cap on that fine of $300, reducing the length of time that the IIDs need to be installed based on some of the discussions we've had today around that, bringing in line with reinstatement, but even shorter amount of times for a first offender to 120 days. We also suggest that you reduce the cost of it that's required to reinstate your driver's license. We're suggesting $25 just as an offset to some of these other fees. And in addition, and Chairman, you mentioned this during your introduction, there is no regulation of this industry. Unlike, I'm sure Representative Momtahan can speak to, that there is regulation of the other programs that are involved here, like the DUI schools. The amounts that they can charge are laid out in statute, and a portion of those fees are returned to the state. So we've also provided the committee with some language that would do the same for IID providers, putting some limits around what they can charge, because if this bill were to pass right now, they could go out the next day and charge whatever they want. And so then the fees that we've suggested to you that could potentially rise immediately. Moving on to the pretrial diversion aspect of the bill, I would also like to address Chairman Setzler's concern about the 0.15 threshold. We agree with him wholeheartedly. Right now, you can, as long as the blood alcohol concentration does not exceed 0.15, that's the threshold, for instance, for being able to enter a no-low plea on a DUI case. So we would agree with bringing that portion of the pretrial diversion program section into alignment with the law. And we are concerned about the fact that the pretrial diversion program does not allow for complete restriction. And we join PAC and the solicitors in their suggestion around conditional discharge. The other thing to note about these programs is pretrial diversion, even if this bill were to pass, right now we don't have pretrial diversions on other crimes throughout the state. Conditional discharge, of course, being a state law, would apply to every court. And so everyone would have the opportunity and access to that sort of sentencing scheme. In addition, the pretrial diversion program also requires IID units to be installed even on a drug DUI case, which we all know that IIDs do not measure anything related to drug use. They're only a blood alcohol concentration measurement tool. So that's just another area of that section of the bill that we would raise some concern about. In addition to the idea that you could have it revoked if you are unable to complete the pretrial diversion program, by making the IID limited driving permit a condition of pretrial diversion. It's not a privilege that's being granted. If the person didn't go through pretrial diversion, they could go and get the IID irrespective of that participation under this bill. So to treat the people who try to take advantage of being under additional scrutiny, it just doesn't seem equitable to us. In addition, with respect to the record restriction that is unavailable through this proposal, there are first offender felony cases where someone can completely restrict their record. And we're basically saying that in this misdemeanor DUI situation, there would still be an availability of arrest and fingerprint type records for the life of that person. Just under the law seems inequitable as well. So we've provided you some amendments in our memo. For instance, reducing another place of cost savings could be reducing the maximum fees allowed for the pretrial diversion program. They tend to cost about $1,000 on top of all the other fees that are associated with the DUI. We have laid out some language around the conditional discharge for you. And we've also made the suggestion around the 0.15 grams and also clarifying that the IID would only need to be used for alcohol-related DUIs. with respect to the post-arrest pretrial incarceration that Representative Bodie was mentioning, we agree that that is a huge problem, and also Representative McLaurin raises the significant constitutional issue of holding someone pretrial in that way without a reasonable relation to a legitimate government purpose. And I also noticed that PAC comes at this from a little slightly different angle in light of COVID, and conflicts also with bail reform that's been happening throughout our state. We would simply ask that you keep that as the status quo at 6 hours, which we could at least agree that there is some reasonable relation depending on someone's blood alcohol concentration. Though we would also let the committee know that people, excuse me, that are held in jail subsequent to a DUI are not driving themselves home. There's many reasons why that happens. Their cars are impounded, their licenses are taken. But anyway, we can at least understand the 6 hours objectively. And then the limited driving permit is another interesting issue. By removing that from the DUIs, actually this body earlier in the session voted to expand the use of limited driving permits in DUI drug cases. This is House Bill 799. That bill was adopted by the House, I believe, unanimously. I might be wrong on that, but it's now in the Senate. It was just this week adopted by the Senate Judiciary Committee without any amendment. So there's definitely some tension between what's happening with limited driving permits right now in this body. We also have some really technical concerns around the limited driving permit that we've reached out to DDS on, and hope we can bring you some additional information after this hearing. We haven't gotten all of our questions answered in that regard, but we will continue to work on that. And I do want to let the committee know that right now there is a provision in Georgia law that allows local jurisdictions to either lease or purchase IIDs so that they can make them available to people who can't otherwise afford them. This law is on the books now, and according to the state court judges, has never been adopted in any of our local jurisdictions. There just simply must be a way for people who are economically disadvantaged to take advantage of these types of tools, and there's nothing provided here that would allow that to happen, and this disparity is certainly a problem. I would like the committee to know that the language in this bill that you are seeing has been substantially modified since it was adopted by the Senate earlier this session. So to the extent that often the adoption of a bill does guide your decision-making process, it is important for you to know that this is not the bill that was adopted in full, and that many of these changes have come subsequent to that vetting. And I would stand for any questions if you have them for me.
Yeah, thank you, Ms. Causey. And just to be clear for members, this is Senate Bill 208 was in the implied consent notice area. So this is very different in the substance. I think Senator Robinson had a bill introduced in the Senate, but to my knowledge, I don't believe it passed the Senate before. But thank you so much for your comments, Ms. Causey. So next we'll hear from the Prosecuting Attorney's Council, and then that will be followed by Mr. Harris with MAD.
Good morning. Can you hear me?
Yes, Ms. Bess, we can hear you. Thank you.
Thank you for giving us an opportunity today to speak regarding this bill. We submitted in writing some of our concerns, but I'd like to briefly go over them. I think the biggest with the at line 96, the 2nd and 5 DUI is one of our biggest concerns, because the current statute requires the person who has reoffended and now is on their 2nd DUI to have a time period, 120 days, where they are without a license. And that is a real inconvenience. Part of the DUI statute, it is an inconvenience. These are misdemeanors to try to help them prevent this from happening again. And so when you have a 2nd and 5, that tells us that the drug and alcohol evaluation and treatment from the 1st DUI and the risk reduction school from the 1st DUI didn't work. And so we have a more dangerous offender. So we would really like you to consider putting back in the 120-day hard suspension and allowing the ignition interlock permit after that. As far as the first DUI, they're allowed, to obtain a work permit, limited permit, on the day, essentially, that they enter a plea. They can take a copy of the disposition, have someone drive them to DDS, and get their limited permit. So the ignition interlock is another treatment tool. I understand from Gactel that there is a concern for there being an expense for it, but the ignition interlock would be another therapy tool for the first offender in an effort to try to keep them from reoffending a second time. You really want to have a chance as a prosecutor and as a criminal justice system that if someone does enter into the system, we can keep them from having to come back a second time. And so that would be an additional treatment tool, even though there is cost. There is some confusion in the bill. Our second issue, we brought that up, and Representative McLaurin and Gactel brought up the disparity between the economic statuses, the rich and the poor, as I will relate it. And that is that in the lines that begin at 204 basically say that if you can't afford an ignition interlock, then you can't drive. And of course, those are usually the individuals with the minimum wage jobs, or they have disabilities and are trying to get back on their feet, and they need some way to drive, to earn money, to pay their basic necessities and their bills. And so that's a concern that we see in the bill. But what's confusing about it is you have the reverse disparity at line 218, because if the person has an extreme hardship, which someone that has financial issues and can't afford the permit is going to be an extreme hardship, then they can simply be given a limited driving permit and they don't have to have the ignition interlock. So a person who is making more money has to pay the additional sums and use the ignition interlock, but someone with less money doesn't have to. So it makes the bill kind of confusing between lines 204 and line 218. So I don't know if you want to address some of that confusion, because I think one of the things that is probably a necessity is that it be clear there, particularly for the courts and for those of us having to apply the law. One of the biggest issues that the Solicitor General's Association has is with the ignition interlock data. Essentially, there's no mechanism to allow us to initiate the process of revoking an ignition interlock permit. This data is all held by the companies, and that presents some problems. Now, I have seen as a prosecutor, and I know my fellow prosecutors have come across people driving on a limited permit, and police officers have stopped them, and they just can't, honestly, they can't lie quick enough. They'll say, well, I was going to the grocery store, or I was going to see my friend, or, I got off work, but I went by the restaurant first. And so I have seen cases and dealt with cases where they are in violation of their limited permit. But I haven't in my career come across an actual violation of the ignition interlock permit, because we don't have the data and there's no way to track it. I think it would make it a more robust treatment or therapy-laden bill if we had access to that. Also, I think it protects the defendants in a way, and I know that seems odd that if we get the data, because most people think the prosecutors are the first one that are going to try to, or the probation officers, to try to revoke their probation. But if you have a rogue ignition interlock company that's, say, extorting individuals and taking money from them, or an employee of an ignition interlock company threatening to remove their ignition interlock if they don't pay extra, then that's something that we can observe the data and potentially protect a defendant from that. I want to address the 24 hours in jail. That was just an information, and I think Gactel did that. Finally, with PTI, our association believes that if this is something that you're considering, we would really ask that you consider conditional discharge. You've really done a lot of additional work that you wouldn't have to do in the bill by just utilizing the conditional discharge or first offender statutes that we already have in 42.860 and 1613.12 but you also have some a contradiction in this form, because 151880E, which we realized this morning, Mr. F. Tracy, when we were initially talking about the bill, that statute states that you cannot use PTI if there are mandatory minimum incarcerations that cannot be probated or suspended. So that's so when I heard you say that they are giving PTI for 3rd and 5 DUI, that the prosecutors or that court would be doing something contrary to 151880E. But it would be a lot less work on you and a lot cleaner to utilize the conditional discharge. Also, it gives them a full second chance. You know, if they come back and they violate a second time, we will see that as prosecutors, and we can enhance the pretrial offer and say, look, you had a break. But if they never violate again, you know, they have the ability to say they were not convicted of this offense. So that's a consideration that we'd ask you guys to think about. I think that's all. I appreciate you letting us speak today, and thank you for making sure I didn't have to go after Representative McLaurin, who graduated from Yale. So I'm glad that I was not after that fella. So
thank you, General Bettis. Well, your diploma's on the wall behind you, so I can't quite see where it's from, but
it is not
you can compare credentials later. So I'll next hear from Mr. Harris with Mothers Against Drunk Driving.
Thank you, Mr. Chairman, for allowing MAD to testify in support of this bill. And this is, as Representative Setzler said, we've been working on this issue since actually 2008 in improving the first offender interlock law. And just addressing a couple things, you know, the cost of these devices are already regulated by DDS. For example, an interlock is capped at how much a vendor can charge for a one-time installation at $75. And it's also capped at the monthly maintenance charge of $75. And it's also capped at the deinstallation charge of $75. And early on in this legislative process, MAD tried to include an indigent program so that those who are unable to afford the device could have it at a reduced rate, but there was concerns that was unconstitutional. Now, we've never seen that in any other state when we've tried to push for indigent programs. So that's why that is not in there. Now, an interlock for 12 months would cost roughly $900 if you add all these fees together in Georgia. So that's roughly 8% of the total cost of a $12,000 DUI. So it's a well worth of cost because it does save lives. And MAD is not just going to hide behind this being a life-saving bill, because it is a life-saving bill, but it's also going to disrupt the way drunk driving is handled. Because right now, the way drunk driving is handled in Georgia is not getting the job done because 375 people are dying a year. 1/3 of first-time offenders are repeating. And that's why we are very much in support of the diversion component of this as well. And we would support a 0.15 threshold as well. And if conditional discharge is something that works better, we're fine with that too. We just want to make sure the state doesn't lose federal funds. And we want to make sure that every single first offender who gets a conditional discharge must use an interlock for at least 6 months, and that there's that data is held. But in interlock, you know, it's effective. Next week, we're coming out of a report on these devices. We found in Georgia over the last 12 years, interlock stopped over 40,000 attempts to drive drunk. That's with a 0.08 or greater. And we found that data from the interlock companies. And that's with a very limited law where there's only 46 installation centers in Georgia. So this is a life-saving approach, and it's not a punishment. It is a treatment tool as well. And this is something that's been before the legislature, the General Assembly, for a while now, and 34 states have laws like this. So it's nothing too earth-shattering. It's really more of a rehabilitative approach as opposed to a punitive approach. And it will move the needle in making Georgia a leader in addressing drunk driving. And we don't want to throw the books at drunk drivers. We want to take a just action. And this is a just action, and it will save lives. And all the studies point to that, and I've sent information previously to that.
All right, thank you very much. Thank you for all of the comments today. I know we're right up on our noon cutoff today, but there are a few hands raised. So, so what I'll do is I'll call on members for just brief closing comments here, understanding that we're going to have an opportunity to work on this legislation and opportunity for future hearings on this. So Representative McLaurin.
Thanks, Mr. Chairman, and I appreciate so much everybody in this discussion approaching this problem with good faith. I appreciate Mr. Harris's comments regarding, the actual numbers of cases that are prevented by the existence of the interlock. I would like a little more clarity because I think part of this discussion is between the first and second offense. What's the additional policy benefit of having it on the first offense? And so, regarding that 40,000 number that you cite, do you have a breakdown of where people are in the number of offenses? Because my guess would be that somebody who's addicted, and this kind of goes to the point of the trial courts and accountability courts who assess people on an individual basis. If somebody's addicted, I can imagine there being a great number of attempts per person. And so I'm just curious if you have overall data on number of people involved and where they are in the offenses.
Just real quick, Mr. Chairman and Representative, I would suspect that most of those people are repeat offenders, because Georgia's law was limited to repeat offenders until 2016. But again, first offenders can have alcohol problems too. And that's why I think also including that diversion component to this is so critical, because if somebody does do something with DUI, they don't have to be part of the system, but they have to meet certain conditions to get up to get their DUI partially expunged. And again, we would support a conditional discharge too. We just want to make sure the state doesn't lose federal dollars. But I would, again, repeat offenders, that's because Georgia's law is limited to repeat offenders.
Well, and if I could, Representative McLaurin, I'll charge you with a little project here if you're willing to take this on. So my question on conditional discharge is, would there be, I know other members of the General Assembly have introduced bills over the past few years to allow for multiple conditional discharges. Are there going to be members who are concerned that use of conditional discharges you've proposed for this circumstance would prohibit circumstances where drug addiction has caused a criminal offense in a what we conventionally think of as 1613-2 type treatment, sentence treatment? And my second question to really put to you would be treatment for a second arrest for DUI if this conditional discharge has been utilized previously, whether or not it's really the discussion you and I were having earlier about whether or not a sentence enhancement would be available under the circumstances or appropriate even for a judge to impose if there has been a previous non-conviction. So that's just what I'd ask you to work on. And I will call on Representative Gravely now.
Thank you, Mr. Chairman, members of the committee, and everyone who's testified today. This has indeed been an area we have discussed. I know for as long as I've been on the committee in the legislature dealing with the DUIs, how do we help? How do we assist? How do we keep our roads safe? And what measures do we take for those offenders? In the posture of wanting to help those that are offending while keeping those that are law-abiding citizens on the road safe. As we go through this discussion, what do we have any updated data? I think we know that when we talk about first-time offenders, this is not the first time, it's the first time they've been caught. But there is a repeat offender mentality there, and I don't know what the percentage is, if there's any updated data that would indicate a first-time offender, maybe this is the first time they've been pulled over and arrested or charged with the DUI before they have to go through the adjudication process. But prior to that, I guess my question is, what are the updated statistics or any type of updated data that we have that would indicate how many times the first-time offender has likely driven under the influence of drugs or alcohol prior to that first arrest? Thank you, Mr. Chairman.
I'll call on Mr. Harris to answer that if he can.
Sure, and thank you, Mr. Chairman and Representative. Most recent data we have is from the CDC as of 2011, which they backed me up when I asked them, and they said on average a first-time offender has driven drunk 80 times before they're caught, and that's on average. So sometimes it might be once, sometimes it might be hundreds. So it's just the first time they've been caught. So roughly 80 times.
All right. Well, I want to thank all the members for participation today. I know we're out of time right now, but there are many other individuals who we'd like to give an opportunity to hear from. And obviously the debate and drafting opportunities will occur offline here so that we can attempt to perfect legislation as we always try to do. I really appreciate, again, the members participating. Hope that everyone has a nice weekend, and I look forward to the resumption of the General Assembly on Monday the 15th, and feel free to contact me or my office if anyone who's watching this today wishes to provide any input for any of the legislation that's been considered. We will do our best to get you in touch with the sponsor or the best person who can attempt to review the communication that's sent. So, all right, thanks so much. We're adjourned.